I'm Jack Fowler. I'm the director of the Center for Civil Society, and I want to thank you for joining us today on May 3rd for this, I think it'll be an exceptional webinar where we are going to discuss the question, and maybe even answer the question, just how important is donor privacy. I think it's something that's been made more important by events of the last 36 hours. For those of you who may be watching this later on a video on the YouTube channel that we have for the Center for Civil Society, you should know that in the last day, the Supreme Court decision, a draft of the decision on abortion rights and Roe v. Wade and being overturned, et cetera, is all the news. And I think it affects, or it will affect the conversation that we're going to have with three really terrific people. I'm so pleased and appreciative that we have this trio. I'm a Yankee fan, so I'm going to say it's DiMaggio, Garrigan, Ruth. If you're a Red Sox fan, well, Ruth was a Red Sox for one time. So I appreciate them being here. Let me tell you a little bit quickly about what the Center for Civil Society is, and then I will introduce our illustrious panelists, and then we will talk about donor privacy. So the Center for Civil Society, which is part of a special project of American Philanthropic, its goal is to strengthen America's voluntary associations by improving the effectiveness of donors, charitable foundations, and nonprofit organizations. The center fulfills its mission through education. It provides research. We publish books. We offer webinars like this, master classes, and in-person events. We just had one in early April in Winter Park, Florida. It was terrific. It was about democracy and philanthropy, and we're going to have another such event in Scottsdale in November. We'll tell you about that when we have all the details. We believe these resources offer practical advice, ideas, training, and tools that help civil society leaders achieve their missions. So that's what we do at the Center for Civil Society. Who is here with us today? Three terrific people. I have to write everything down because I can't improvise anymore. I'm too old to do that now. So Howard Husak is a senior fellow in domestic policy studies at the American Enterprise Institute, where he focuses on municipal government, urban policy, civil society, philanthropy, and other issues. Howard's the former vice president for research and publications at the Manhattan Institute. He's widely published, name a newspaper, name a magazine, he's written for it. He's got several books to his credit. The most recent is The Poor Side of Town and Why We Need It. Also, Who Killed Civil Society? The Rise of Big Government and Decline of Bourgeoisie Norms, and another book, Philanthropy Under Fire. Howard was a mid-career fellow at Princeton University's Woodrow Wilson School of Public and International Affairs. He has a BS from Boston University's School of Public Communication. That's Howard. John Bursch is senior counsel and vice president of appellate advocacy with the Alliance Defending Freedom. And in that capacity, he was the chief counsel in the critical 2021 case. It goes by two names. We're going to say Thomas More Law Center v. Bonta, but it's more generally known as Americans for Prosperity Foundation v. Bonta. That was the important 2021 case where the Supreme Court ruled on behalf of, in defense of donor privacy. John had an important role in that case. He's a former Michigan State Solicitor General. He has argued 12 cases before the United States Supreme Court, 30 before other state Supreme Courts. He has his own law firm, Bursch Law PLLC, represents Fortune 500 clients, governments, you name it, he represents, high profile. John was a law clerk to the Honorable James B. Loken on the U.S. Court of Appeals for the Eighth Circuit. I have it, John, on good intelligence that you never released a draft opinion. I think that's He received his JD magna cum laude from the University of Minnesota Law School, and he graduated from Lee Honors College. Elizabeth McGuigan is here with us also. Thanks so much, Elizabeth. You're the Director of Policy at Philanthropy Roundtable. You've been there for a little over a year, and before that, at the Roundtable, you were the Director of Legislative and Policy Research for the National Shooting Sports Foundation, where you oversaw state and federal policy research and helped to protect the Second Amendment In your current role, you support Philanthropy Roundtable's Policy and Government Affairs team. You provide research and analysis on critical issues facing the charitable sector, philanthropic freedom. You have a BA from George Washington University, right? And a Master's of Public Policy, both from there. And before Shooting Sports Foundation, you also work for Bloomberg Government, Strategas Research Partners, Jason Trennett, we love Jason, and Americans for Tax Reform. So it's quite a trio we have here today to talk about a very important issue. And I'm going to begin the conversation. I have a number of questions to ask. By the way, folks, if you who are participating, if you would like to ask a question, ask it in the chat. There's a Q&A box, and Maria Danselmi, my colleague and great helper, will get it to me, and we will try, if there's time, to have your question asked. So Elizabeth, to give this a little drama, there was in the not too distant past, we're going to talk about the donor privacy right. I'm going to say it came under attack, first by a legislature, then by bureaucrats, then by an attorney general. Certain entities, certain nonprofits felt that this was a threat, and they urged the courts to oppose the threat. Certain courts told these certain entities, too bad. But the final court, the ultimate court of our land, the United States Supreme Court, told government officials, too bad, you lose. The complaining organizations are right. Donor privacy needs to be protected. Elizabeth, I'd like you to give us the background of what happened. I want to say, first of all, donor privacy is much more than about a specific case, but this is a pretty big case. This is pretty important to the matter at hand. So would you tell us about who did what was their pretext and motivation for doing what? Why did certain nonprofits take legal action that ended up with this 2021 United States Supreme Court decision?
Sure. Thanks, Jack. I appreciate the opportunity to talk with you today, and I'm honored to be on the panel with Howard and John. So the background here is that in 2010, California's then State Attorney General Kamala Harris began requiring nonprofits to file their IRS Form 990 Schedule Bs with the state. So the Schedule Bs include the names of major donors, and generally those who contribute $5,000 and above. And the state argued that this was for ease of investigations and enforcement activities. The problem with California requiring these forms to be filed with the state was that it has very weak protections for this information. Nearly 2,000 of the forms were directly posted onto the California website. Another 350,000 documents were easily accessible through a website vulnerability. So there was no protection for donors and for their information within the state government. So due to both the intentional posting of some forms and the website vulnerabilities exposing others, Americans for Prosperity Foundation donors face significant harassment, including death threats against themselves, their children, and their grandchildren. So the lack of confidentiality and the resulting threat to the safety and privacy of donors was really the crux of the complaint.
Trying to unmute there. Thanks for that, Elizabeth. John, I'd like to ask you now about the actual, well, if you take us, connect the dots a little, John, if you don't mind, what happened before the Supreme Court, what courts were involved in this case, and the principal parties to the case. And then the big question I want to ask here, I'm going to assume that the 2021 decision, it was a 6-3 decision that Justice Roberts wrote the majority opinion, that it was a good decision. It may even have been an exceptionally good decision, but I want to leave the qualification of that decision to you. And I want to know, when it comes to donor privacy, what did the majority get right? What, if anything, did they leave exposed? Did they have is donor privacy sacrosanct now? And on the dissenting opinions, I'm not sure if it was an opinion or opinions plural. I know Justice Sotomayor wrote a dissent. What was the particular major thing that the dissenters got wrong about this action?
Sure. Thank you as well for having me on in this great panel. This is an important topic and glad that we're discussing this. As you mentioned, I represented Thomas More Law Center, which along with Americans for Prosperity Foundation were the two primary litigants that resulted in the Supreme Court case. There had been a previous case that had gone up to the Ninth Circuit on a facial challenge, and that was rejected by the Ninth Circuit. And so when Thomas More Law Center and Americans for Prosperity Foundation came along, they started in a district court, and it wanted to rule for them on a facial basis. In other words, the statute is so unconstitutional for invading donor privacy that it's unconstitutional in all circumstances, not just to these litigants. But after that holding, it went up to the Ninth Circuit, and that other decision controlled and sent them back down to the district court. So they actually both had two separate trials where they had to prove that their particular donors would be affected by the possibility of these disclosures. And in a very detailed opinion, the trial court ruled in their favor and found numerous facts in their favor, including some of the ones that Elizabeth mentioned about the lax security in the California AG's office. That went back to the Ninth Circuit, and the Ninth Circuit reversed again and said that the government security problems had been patched. They were not. And also said that the government's interest in obtaining this information was more important than the donor's interest and the charitable organization's interest in keeping it secret. And so that's what then went up to the US Supreme Court. And I'm a big fan of the decision. You never complain when you win, especially when you win on the basis that a statute is facially invalid, because that protected not only these two parties, but every charitable organization that does business by soliciting donations in the state of California. If I was going to quibble at all with the majority opinions, they didn't resolve what tests should apply. Our position was that the importance of donor privacy was so critical that the court should apply the most stringent test to a government that wants to compel private, confidential donor information, strict scrutiny. And instead, the plurality opinion applied what's called exacting scrutiny. It's still pretty tough scrutiny. The government needs to have important reasons, and the means that they need to obtain those goals need to be relatively connected to each other, but it's a little less than strict scrutiny. And we thought the protection could have been even higher. Now, a majority of the court did not sign on to that exacting scrutiny test, so technically that's still an open question going forward. Another thing the court didn't do, and I know we're going to get into this a little bit later, is it didn't take the opportunity to ground donor privacy in the Freedom of Assembly clause in the First Amendment. Historically, that's been an ignored clause. And like I said, I know we're going to get into that. But instead, they stuck with their recent precedent, which has grounded these types of privacy rights in the free speech clause. And that's a fine place to put it. But over the long haul, it would be a stronger foundation if we moved more towards an assembly clause analysis. The last thing is, and this isn't the court's fault, but the opinion is going to be forever linked to the facts of this case. So in a future case, if you have a state that has a lock, stock, and barrel approach to keeping donor information private, might there be a different result? Part of the problem here was that California leaked information like a sieve. And that's something we can get into later as well. There was one dissent, and you're right, that was Justice Sotomayor on behalf of 3 justices. And what was interesting is that they didn't really have a problem with the majority's conclusion that these two parties had a significant risk of their donor information being disclosed and having those donors either being threatened or doxxed or having lost opportunities to get monies from donors because of the threat of threats and doxing. They didn't really have an issue with that. But what they disagreed with was that this ruling should be applied on a facial basis. They thought that every one of the tens of thousands of charities that solicit funds in California should one by one have to go to court and prove that they were in that same situation. And then the majority rejected that out of hand.
Thanks for that, John. We'll get into some of those points, legal points, later on. I'm glad you raised them. I'd like to bring in Howard at this point. So Howard, I have 2 questions for you, and then we're going to move on to Elizabeth. We talked about this a little, we communicated a bit about this earlier. And there was a significant amount of amicus, friends of the court briefs that came into play in this case. Would you qualify, would you talk about how much this case, when it got to the Supreme Court level, mattered to many organizations and across ideological spectrums.
Well, thanks for that question, Jack. To me, that's one of the great triumphs, and the attorneys who were involved, like John, deserve great credit for assembling that cast of characters. This was really a situation in which American civil society, quite broadly and across what are known as partisan lines generally, responded to what they regarded, what various organizations clearly regarded as a serious threat. So that cast of characters, as I'm calling it, included not only Americans for Prosperity, the litigant, and Thomas More, the other litigant, who might be considered social conservatives, but the American Civil Liberties Union, the NAACP Legal Defense Fund, the Libertarian Cato Institute, and a much longer list that goes beyond that. And so the fact of their assembling, to borrow John's reference to the Constitution, was itself significant. It certainly was a predicate for the victory, but the fact that they agreed was itself significant. I'd just like to add one thing to John's previous remarks. The reason this came to court in the first place, as I understand it, was it wasn't just that Kamala Harris got it up in her own mind that she was going to ask for these Schedule Bs. It was the law in California. It had just never been enforced. It was her discretion as Attorney General of California at that time. She was going to enforce that law. So she was actually quite central to the case.
Well, let's talk about that. The case as it ends up, the name Bonta is the name on the actual final ruling by the Supreme Court. But prior to that, the case had other Attorney General names. Becerra, who's now the Secretary of HHS, he was California's Attorney General during this, while this prolonged. Kamala Harris, and I think there was someone named Rodriguez also, I think, who temporarily was acting Attorney General. So there were a lot of, Bonta had three other AG types on the case. But the important one is Harris, as you just mentioned. Howard, this was a law, the law was passed, it's kind of sat there and nothing happened. And then she made an active decision to initiate what we might call in the Bronx, cause trouble. And well, as you wrote for The Hill last year, the title of a piece, op-ed piece you wrote is "The Supreme Court Donor Ruling is a Defeat for Kamala Harris." So I'd like you to talk about that. And I don't know, I'm going to say it was a not small defeat for her. That doesn't mean it was a big defeat, but it was a defeat. You wrote the piece. How does this backlash on her, if at all?
Well, it's really fascinating. I believe the law was originally passed in 2001, and it kind of sat there. And the fact of Harris's active enforcement of the law really raises a lot of questions. So if the law was necessary to prevent fraud and abuse, that was the what enforcement was hanging its hat on, as I understand it, that if bad things are going on, we have to have access. We need to know who's involved in case they have conflicts of interest. The fact that there had not been such actions during the previous decade, nor, to my knowledge, significant requests for such information, and John may know more about that than I, it calls into question then Attorney General Harris, now Vice President Harris's motives. That's what's opaque, but one wonders about them.
Well, when you wonder about them, how do you speculate that I'll put it out there, was the motivation political?
Well, the fact that that there is a liberal progressive talking point about dark money, about anonymous donors who are pulling strings. So this is out there as a political talking point. And so lifting the rock to see what this group or that group is supporting financially was part and parcel of that approach.
I would like to ask Elizabeth a question about some of these amicus briefs that were filed. But first, John, I don't know if you can answer this briefly, but if the Ninth Circuit ruling stood, if the cert was not granted, by the way, I'm curious, were you concerned? Was there any point where you thought, okay, the Supreme Court might not take up this case? I mean, that's a fact. They might not have taken up this case. But if you were a betting person, were you confident that it would be taken up, or was this, or not confident?
We were pretty confident that the court takes up less than 1% of the cert petitions that get filed. And so you can never say with 100% certainty. But as Howard mentioned, the outpouring of amici support across the political spectrum was a strong signal to the court that there was something clearly wrong here. And so that gave me great confidence. In addition to his other point about the pretext, there was fantastic trial evidence. The employees in the AG's office admitted that they had never used the information on a Form 990 to initiate an investigation of a charitable organization, and further admitted that if they had to investigate and request Form 990 information, they had been able to successfully get it in every single case after the fact. So you kind of have this combination of a groundswell of support with a story by the Attorney General's office that really didn't hold water based on the testimony at trial. That gave us great confidence.
John, I assume most people who are watching this know what a Form 990 is, but for those who don't, could you just briefly explain what that is?
Lots of them have filed those forms.
Yes.
I believe Elizabeth mentioned this right at the outset, and this is the form that you have to file that has your top donors on it, their identities and how much they contributed. And obviously those are the folks that you most worry about, because in the case of AFPF and Thomas More Law Center, they were the ones who were most likely to be doxxed, whether that was through protests, public shaming, or even death threats, which was evidence in both trials. And it's the risk to those donors, but also the risk that donors in that category will no longer give because they're worried about being next. That's really where the serious problem lay.
Elizabeth, you can pass on this if you want to or not, but there were not every nonprofit organization felt the same as the amici who were on the side of AFP and Thomas More. There were a couple that filed amicus briefs, a couple of organizations, the National Council of Nonprofits, the California Association of Nonprofits, who filed on behalf of California Attorney Generals. Would you speculate what their motivate? I mean, they wrote what their rationale was, but I don't know if you've read those briefs, but would you speculate as to why some nonprofits would actually back the Attorney General's office on this?
Well, I won't speculate specifically to their exact intentions, of course, but I think just to echo Howard's point, I think that the real message here is that you had almost 300 groups coming out in support of the petitioners. So for the fact that there were a handful of nonprofits and nonprofit associations coming out and supporting California, it's not a huge surprise, but it is such a small minority in these voices that were really opposing the donor disclosure regime.
Well, Elizabeth, let's talk about the broader question. We've been talking a lot about this case, and we're still going to talk more about the case in a little bit. But you wrote a policy primer, very important policy primer for Philanthropy Roundtable in November, and it's called Donor Privacy, a Constitutional Right for American Givers. And in our little chat box, there'll be links to that and some of the other things, John's brief, some of Howard's articles. In that document, you talk about the valid reasons why donors want their charity to be anonymous and private. So outside of Supreme Court cases, et cetera, what are the real motivations, the core reasons that a donor and a philanthropist wants anonymity and privacy?
Sure. Well, I would say that, of course, the central point of the policy primer, of course, is that donor privacy is crucial to fostering charitable giving and voluntary association. So many donors, as you said, might choose not to give if they can't keep their donations confidential. So for some, this desire for privacy might stem from longstanding religious traditions of anonymous giving, or for some, it could be simply from a sense of modesty or desire to keep the attention on the good work of the nonprofits themselves. Some donors may also wish to remain private in order to avoid unwanted solicitations, or out of concerns, as we've nodded to earlier, that their donation may spur harassment and retaliation. You know, we know we live in a time of rampant cancel culture, so it's understandable to be concerned that one's associations might be controversial now or might become controversial even in the future. So really forcing such disclosure against the wishes of the donors ultimately leads to less giving and would undermine the ability for charitable organizations to help fulfill their missions.
Howard, I think you wrote a piece, and I don't know if I found that and I put it up in the link, but I think you did I think you wrote it for National Review right before the decision that calculated some effect, how the impact of on actual giving would be. Did you not? Did you write something? Did you make some estimation of what the impact on overturning I'll call it overturning donor privacy would be on actual giving?
I probably did, but I don't recall. But I will say this. It's worth noting, I did do a paper for the American Enterprise Institute on anonymous giving through donor advised funds.
Yes.
And which I'm sure many of the viewers and listeners here are familiar with, are a very fast growing vehicle for philanthropic giving at the household level. And it turns out by culling the records of Fidelity, Vanguard, Schwab, and National Philanthropic Trust, which are the four horsemen of that field, it's only about 5% of donor advised fund donor advisors who request anonymity. So maybe it's only 5% of all donations that are lost. Well, that's a lot of money when you're talking about $300 billion a year, $400 billion a year in charitable giving. If you use that as your yardstick, I'd also like to, if I might, pick up on one of the important precedents that I know figured in the case and in the jurisprudence. It's the 1958 NAACP versus State of Alabama case. And we just shouldn't forget this when we talk about doxing and canceling and harassment. Well, the original precedent for assuring the anonymity of donors to the NAACP Legal Defense Fund in 1958, when the state of Alabama wanted a list of its donors. Can you imagine the beyond harassment? This was a time when civil rights workers were being lynched. So the potential exposure is very dramatic, and that's a backdrop for this case too.
Let me keep on that, Howard, because that was my next area I was going to go into with you, because one of the other amicus briefs of some note that was supportive of the Attorney General's was one from several United States Democrat senators. I think it was led by Sheldon Whitehouse. He seems to be very much of a point man on these issues. Here's a little quote from that brief. Amici, I hope I'm saying that right. Amici senators caution that every expansion of, quote, dark money's reach, particularly the broad expansion of dark money rights sought by petitioner and numerous amici here, will further degrade our already troubled politics and public discourse. So I raise this, Howard, because you wrote another piece for The Hill. It's titled Donor Privacy, a Civil Rights Lesson Democrats Should Remember. So these same, I'm not trying to be partisan here, but this fact, it was an amicus brief written by Democrats who are very pronounced on the issue of donor privacy, and they seem to have forgotten its roots. So the question I want to ask here, Howard, you partially answered already, is what was the role that civil rights played in fortifying the Supreme Court's and the American public's holding that donor privacy was fundamental to life, liberty, and the pursuit of happiness. And shouldn't all senators, all representatives remember that?
Yeah, it is curious that Senator Whitehouse was at odds with what are historically known as liberal groups, the Civil Liberties Union, NAACP Legal Defense Fund, which of course had been active in that Alabama case too. And so what strikes me in the statements you read about dark money, of course, that's a pejorative to talk, we talk about privacy and others can talk about dark money, and one can talk about Orwell in the English language, you know, it depends how you use the phrase. But the senator talks about, or that brief talks about how dark money is harming our politics. Well, charitable giving is not necessarily or even generally about politics. So it's quite curious that that brief would have raised that particular flag. And I think to be even-handed about this, one wants to separate charitable giving and political giving and think about the regimes governing them in different ways. I understand that in following the Citizens United case and which are on people's minds, like Senator Whitehouse, there's concern about corporate giving and a desire for corporations to have to reveal their giving. There's 501c4 organizations which are by definition involved in politics. We can have a long conversation about whether political donations, political committees that are formed in support of candidates, against candidates, ought to reveal their donors. That's a different conversation to have. This is a conversation with the AFP v. Bonta and Thomas More Center v. Bonta case about charitable giving. And the majority of charitable giving does not go to public policy related or political cause related advocacy giving at all. Certainly it could go for a Planned Parenthood clinic without advocating for pro-choice legislation. Somebody may just want to support that particular physical space, and they would be exposed in a way. So politics is one thing, charitable giving is another. Anonymity, privacy is what we're talking about here as it relates to charitable giving.
Okay. John, back to you. I'm not going to read the quote. I mean, you did talk about in your, you filed, maybe in the last brief file before the actual oral arguments on behalf of the Thomas More Law Center, is where you made your very unvarnished, it wasn't an accusation, it was a description that the California government leaks private donor data like a sieve. John, I'd like you to speculate a little here. What if California did not leak like a sieve? What if it just would have been an impossible thing for there to be such, leaking and the information would have been sacrosanct in some way? Would that really have mattered? Did donor privacy protection depend upon the leakability of information? That's a technical term.
Yes, it did not. That was just a really fun fact that made a strong case almost fireproof. But it really didn't matter, because it's the threat that information could be released even in the world's most fail-safe system. So, compare and contrast California with the federal government. In California, they use temporary workers and student workers to put this information in their database. That's how many thousands of documents ended up either on the web or easily accessible on the web, as Elizabeth was talking about. There were no criminal penalties. You didn't lose your job if you disclosed information to someone. This was about as low security as you could get. Now compare that to the IRS, which has a much stronger need for donor information because they need to verify that for tax purposes. And they've got strong criminal penalties if you disclose, and they've got information that they don't put on a server or on the internet, so no one can hack it. It's all just in their offices and things like that. It's what some would say much closer to a Fort Knox of information security. But even there's a very prominent case where someone inside, notwithstanding the threat of criminal penalties, disclosed a donor contribution, and that resulted in them being threatened and undergoing all kinds of public scrutiny. And it's the threat that could happen, no matter how fail-safe the system is, that causes donors to be reticent about giving if they know that they could end up on that list, that they could end up being the ones disclosed. So both as a practical matter and a legal matter, it didn't matter that they were secure or not secure. In the same way in the NAACP case, if officials could guarantee that no one's name was going to be released from that list, people still would have not associated themselves with the NAACP out of fear that that might still happen by some bad actor. And that's why across the South, in states that had those mandatory compulsion laws prior to the Supreme Court ruling, the NAACP lost 50% of its supporters over a 2-year period. I mean, it's just dramatic what happens when people who are giving or associating themselves with organizations that are politically unpopular or controversial, that they need that anonymity in order to be able to participate, full stop.
John, you mentioned it before, and I'll stick with you, and then Elizabeth, I want to talk to you about the donor privacy, civil society nexus. Part of what the Supreme Court decided in the case was about voluntary association. So I have a couple of rights questions. Could you tell us briefly, because we're clipping along here time-wise, really, where does the right to association as it relates to donor privacy, where does that reside in the Constitution, or is there a major case which pronounced on that makes it almost settled law? Is there such settled law? And I have a question. Is it possible that there is a right to donor privacy that is not intertwined with the right of voluntary association? Or are the two just inextricably extricable?
Well, the NAACP case was one that grounded the association right in the free speech clause in the First Amendment, and all subsequent cases have done that same thing. As I intimated at the beginning, the assembly clause might actually be a better place to draw that reservoir of protection, because that's all about people getting together for a common purpose to express a common message. So if you looked at the history and said, all right, what were the ratifiers of the Bill of Rights, and specifically the First Amendment, thinking about, association would have fit more naturally in their conception of what it meant to assemble. So, over the next several decades, you're going to probably see more legal advocacy urging the court to pick that up as a thread, because it's just the natural home for that kind of privacy. I want to draw a distinction between that kind of privacy and that involving personal bodily privacy, which is what we've been hearing about in the last 36 hours with respect to Dobbs and Roe versus Wade. Very different type of privacy. The 14th Amendment has a due process clause. And as originally envisioned, it was supposed to make sure that no one was deprived of their legal rights without due process, plain and simple. But about midway through the last century, the Supreme Court, first in a case called Griswold, later in a case called Roe versus Wade, decided that there was also a substantive due process protection, one where they could make up whatever right they wanted and stick it into that substantive due process theory, and then create rights that the court wanted to protect. Very, very different than free speech and the Assembly Clause, which protected long-held historical protections for freedom of association and donor or associational privacy. So I think what we're going to see in the Dobbs case, if the leak is accurate, is the Supreme Court starting to pull back in that area and saying, look, if the Constitution is silent about these substantive rights, we can't make them up. You got to achieve those through the democratic process. But when it comes to free speech and assembly, those rights are clearly and expressly articulated in the Constitution. So no matter what happens with Dobbs and privacy of the body, we don't need to worry about that impacting privacy in the donor context or the privacy of associational rights.
Thanks, John. Appreciate that. Elizabeth, I want to get in now into the broader, colorful picture of donor privacy and how it relates to civil society. You touched on that before. I have an image of the game of Jenga, which I know I would lose on the first block I pulled out. But if we consider that civil society is a block in this, or donor privacy is a block in civil society, the civil society Jenga structure, and it was pulled out. How what would the effect be on civil society if donor privacy was removed?
Sure. Well, I love this question, Jack, because it actually lets me promote a paper that we have coming out in the next couple of weeks. We know the right of individuals to decide whether they want to be publicly associated with their favorite clauses is at the core of civic freedom. But I think this is best illustrated through examples. So our forthcoming paper includes stories of anonymous giving in all 50 states. And what we found was a really broad range from those concerned about their safety to those who simply want to remain private because they're private people. So I'll walk through two quick examples, if that's okay. In Ohio, for example, an anonymous donor helped to free a group of missionaries that was kidnapped by a gang in Haiti in 2021. So while the donor who helped free the hostages chose not to come forward, it's easy to imagine that there were legitimate safety concerns that he or she may have with being public in this effort. That's a clear reason. We know why they want to remain private, but it's something you might not think about in the broader debate. Now, on the less controversial side, in 2008, two siblings gave $10 million to their village in Wisconsin. And the goal was for the donation to build a new municipal complex. And these siblings strongly desired that their gift was going to remain anonymous. So they were very angry when a local paper published their names against the advice of the village administrator, even after the donors themselves sent a letter to the paper asking to remain anonymous. So in this case, there's no immediate tangible harm that came to the donors from their unwanted exposure, but they were certainly unhappy with the result and are unlikely to ever give again. So these are just a few examples of how private gifts really support varied causes and varied communities throughout the country. So you take away the right to privacy, you take away that Jenga block, and you will inevitably lose some of this support.
How would you want to weigh in here a little bit? I mean, how central is donor privacy to civil society?
Well, I'll just turn it around for a minute. Why would you want to, you wouldn't want to compel privacy either. It's the choice that's really available to us, as free Americans. And most giving is voluntarily non-anonymous, and non-anonymous giving has actually tremendous benefits for civil society. When, if you go I go to my local YMCA many days every week, and there's a roster on the wall of those who have made donations to support the Y. And those people are saying, well, I would like to advertise my gift so as to inspire others to give. That's a choice that they have. And so similarly, the choice to be private is a choice. It gets to not only what good it redounds to civil society, but to a core notion of liberty, doesn't it?
I have to take a commercial break. That was a rhetorical question. I just want folks to know if they're interested about what we do at the Center for Civil Society, visit our website, centerforcivilsociety.com. As I explained earlier, we have webinars and convenings, et cetera. You'll find all that we do there. I write a weekly free email newsletter called Civil Thoughts. You can sign up for that at civilthoughts.com. It's free. There's no risk, no strings attached. It's interesting. Now this gets a little dangerous because I have bargain basement theology here, but I did know walking around the Capitol many years ago and saw these bas reliefs. There were about 2 dozen or so of jurisprudence leaders through history. You'll find Napoleon, but one is Maimonides, the great Jewish scholar, Torah scholar, and he wrote very importantly about charity. And I have to get this in here. I was just researching something recently also. There are 8 forms of charity according to Maimonides, and the top one is about this has to do with Jews giving to another Jew to keep them out of dependency. So that's the top for him. But the next one, the second most highest of the 8 forms of charity is this. He calls it a lesser level because 7 is less than 8. A lesser level of charity in this is to give to the poor without knowing to whom one gives and without the recipient knowing from whom he received. For this is performing a mitzvah solely for the sake of heaven. This is like the anonymous fund that was in the Holy Temple in Jerusalem. There the righteous gave in secret and the good poor profited in secret. He wrote more, but I'm just serving this up, kind of goes back towards what mentioned earlier about certain senators. This is a critical understanding of charity, and that privacy and charity at its highest form is private, according at least to Maimonides. This seems to be lost on many political leaders. Do you think, I'll just throw this out to you, Elizabeth, everyone can take a whack at it. Do you think our leaders even have the slightest clue about charity and privacy and how preeminent it is? Or do they know and don't care?
Well, I would say that probably even when they do consider and know about charity being private for religious traditions, there's sort of a growing distaste for respecting those kinds of traditions and cultural norms. I think we live in a time of social media and cancel culture where there's far more focus on public activities and conforming views than on private voluntary association. But I think it's interesting, Arthur Brooks had an article recently about the warm glow that studies find givers receive on giving anonymously versus on declaring their giving. So I think that even outside of those considerations, there's still modern arguments for anonymous private giving.
And certainly we saw that religious component play out at the trial for Thomas More Law Center, because Thomas More Law Center is primarily a religious organization that defends religious liberty and protects life, protects the family. And so many of their donors are religiously motivated. And we had an expert witness who testified at trial that anonymity was an important principle for many of those, not because of doxing or because of concerns that others would be asking them for charitable donations, but merely because the Bible instructed them that their giving should be anonymous, that if they broadcast to the world that they were doing this giving, that would take away in God's eyes the gift that they were making.
I will say, just to inject a note of complication, giving to a hospital, giving to for medical research, those kind of direct aid given for a hunger program, people understand those kind of things differently than they understand Americans for Prosperity, which has a public policy agenda. We've seen charitable giving move into trying to influence public policy really since the emergence of the Ford Foundation in the 1950s. And now we have a tremendous buffet of across the policy spectrum of organizations trying to inject advocacy into the public debate, including the one I work for, the American Enterprise Institute, and other think tanks. And so we shouldn't be surprised that politicians take notice of this and put it in a different category of charitable giving. I don't happen to think that means it should not be private. And I'm glad that the Supreme Court didn't think that it should not be private, but it is understandable that it's viewed in a different light.
Well, let's consider let's stipulate, I will stipulate for me that there are enemies of donor privacy. I don't want to put words in anyone's mouth. And even though the Supreme Court in 2021 ruled an exceptional ruling on behalf of the right to donor privacy, it still has its scheming enemies who are trying to find ways to weaken it, undermine it. John, if you don't mind, first leads to a little, maybe there is nothing percolating out there, but could you see ways through the courts that enemies of donor privacy would try to figure out a new way to accomplish it that was struck down through Americans for Prosperity? And then I'd like to ask, Elizabeth and Howard, both I think you have written about, and Howard, you touched on other organizations, the ACE Act, I think it's 1981 or 1891. There are clearly are efforts on Capitol Hill and maybe in some state legislatures to address, go after donor privacy. John, any thoughts about things percolating through the courts or a means to do
Yeah,
that?
nothing really percolating, but as I think about future threats, one certainly is that cases are always fact dependent. And so if you had a different regime that had a tighter security system, that maybe didn't have a blanket disclosure requirement, but something more targeted, there are other ways that you could go about trying to do what California did in less offensive ways. California was kind of an extreme example, and so that made it easy for the Supreme Court. The other one is that there are some instances where it's legitimate for the government to have information. So we talked about the IRS and how essential it is for them to be able to have access to donor information so that they can appropriately make sure that deductions have been taken on tax filings and things like that. Most states simply accept your adjusted gross income from the federal government, so they don't have the need to do that. But if you had some kind of a state tax system that depended in part on giving credits for charitable donations, all of a sudden that would create a vastly different government reason for wanting to collect that information, as opposed to a prophylactic convenience, which is what California articulated. So, if there was ever a merger between tax collection and donor privacy and disclosure at the state level, that could be a potential risk, and that would be one that we'd have to look very closely at. Again, the example of the federal government, the IRS employee, notwithstanding the lockbox having leaked information, now all of a sudden that could be a multi-state risk. So what do you do with those kinds of situations? That's if there's going to be future policy and litigation in this area, that's where I see it going.
Yeah, and it would be so complicated because there could easily be understood to be benefits to having state exclusive charitable tax deductions, which is what you're imagining, right? Because as a result of the 2017 Tax Reform Act, Tax Cuts and Jobs Act, very few Americans now itemize their taxes and avail themselves of the charitable deduction. So a state that wanted to encourage charitable giving might want to adopt a expansive charitable deduction for its own state taxes, but yet it might open the door to exactly what you're saying.
Correct.
Elizabeth, would you talk a little about, you've written about the ACE Act yourself, haven't you?
Yeah.
And maybe I'm over painting brush too broadly, say people going after donor privacy, but I think a case can be made that going after donor advised funds is really a means to address donor privacy. But how are people trying to affect donor privacy through the legislative process?
Sure. Well, I would first of all say that luckily in the wake of the Supreme Court decision, the states have been fairly quiet on the donor disclosure front this year. I mean, we went from tracking donor disclosure bills in 15 states last year to only 2 this year. And a few are even considering proactive legislation to explicitly protect donor privacy. But what we are concerned with in states like California and on Capitol Hill are the more narrowly targeted disclosure efforts aimed at donor advised funds. So again, these popular charitable giving accounts, as Howard mentioned, they allow for anonymous giving, and they are increasingly under attack by lawmakers. As you mentioned, the so-called Accelerating Charitable Efforts Act is a big threat to donor advised funds and to donor privacy through different restrictions that it would place on these donations. So with bills in the House and the Senate for the ACE Act, this legislation would undermine the ability for donors to use donor advised funds for private giving, whether you're a private foundation using a donor advised fund or an individual donor using a donor advised fund to facilitate a non-cash gift to a charity. You would see more disclosure requirements to give information to the IRS if this were passed.
The very prevalence of the term dark money, I think, is a threat to donor privacy. The very acceptance of that term as a thing, right? Because it implies, not too subtly, that anonymous giving is nefarious in motivation and purposes. And that's, I mean, could that ever happen? Sure, but it's not the norm.
I want to apologize for some of the yelling out in the hallway if you heard it. There seems to be a wrestling match out there. We only have a few minutes left. I'd like to ask Howard, if you just take 1 minute and answer this, and then the final question will be 1 minute for each of you to answer the question, just how important is donor privacy? We'll end on that note. But Howard, again, this is speculating. This has to do with Kamala Harris. I mean, you did write about her. And, you know, she is, as any vice president is, one heartbeat away from the presidency. Do you think if Kamala Harris was president, that she would take a particular interest in this issue? Is what she did in California is just something that happened because she was attorney general? Or do you think she has a passion for this?
Well, I'm not aware of her speaking.
You don't know, you don't know. That's, yeah.
I would say this. I think there was the stars aligned for her in California, where there were a fat target, the Americans for Prosperity, which was demonized by progressives. And so that was a good reason for her to do what she did. Whether the political stars would align the same way, she certainly would be open to it. There's no doubt about that.
Okay. John Bursch, I want to first I'm going to thank everyone one by one, but John, thank you for participating. John, just how important is donor privacy?
It's so important that it's coextensive with the importance of democracy and flourishing in our country. You know, we all like to think that because government does so much that it's responsible for everything that's good in society. But if you took away charitable donations because of a loss of donor privacy, you know, you lose soup kitchens and orphanages and contributions to education, both at the college level and at the high school and below level, access to libraries, to parks. You know, there's so much human flourishing that happens as a result of charitable giving. And you put all of that at risk when you say, well, if you want to put your name on that check, then you also have to be willing to disclose that to the world, whatever the cause might be. So it's absolutely essential. And that's why the Supreme Court ruling was so important.
Marie, Elizabeth, I want to say thank you to Maria Danselmi for helping me here before I forget that, because we're running out of time. Elizabeth, thanks for participating. Elizabeth, just how important is donor privacy?
Sure. Well, I would certainly agree with what John just said. I would say that in general, the right to donor privacy is the foundation for American civil society. And we really need to protect that both through the courts and through the legislative process.
Thanks. And Howard, thank you, my friend, for being here. Greatly appreciate it. And Howard, please close us out here with just how important is donor privacy?
Well, I'll echo what John said earlier about the importance of voluntary association, and anything that diminishes the right to voluntary association or threatens it, and that would include being forced to make public your support for any organization, would threaten that voluntary association. And as much as anything, voluntary association is vital to liberty and democracy. And all you have to do is to think about China as a contrast. There's no donor privacy in China because there's no privacy of any kind in China. And that's a very different society.
Well, my friends, thank you so much for participating, for sharing your wisdom. This was a great conversation. This will be up on YouTube soon. You can share it with your friends. Those who were watching today, thank you for coming. I hope you found this worthwhile and educative. I certainly did. And we'll be back again next month with another webinar from the Center for Civil Society. And until then, thank you very much, and God bless America. Bye-bye.